Namaste Bharat. My name is Disha Kotari, intern at Law Chamber of Siddharth Murarka, and today's webinar has been hosted by me. Today we have speaker Pradeep Sancheti, Senior Advocate, Bombay High Court, and he will be speaking on today's topic, that is law relating to quota and reservation. Now I hand over the session to Shri Sancheti sir for enlightening his vast knowledge and experience on the said topic. Thank you. So now you can continue.
Thank you, Disha, and good evening, everybody. I hope you are all safe and sound wherever you are in and around Mumbai or elsewhere. With COVID and cyclone times, you are not in Nisarg, but otherwise in good place. The topic of today's, I would call it discussion, although it's monologue, is about reservation and quota, the law relating to reservation and quota. As we all know, this is a rather hotly debated topic. In some ways, it's a controversial topic. In many ways, the opinions are polarized because some people are strongly for it, some are strongly against it, and many are on the balanced track. What should be the right way of handling this reservation and quota? My effort is going to be to take you on that middle path, although I must caution you that because I have had the occasion of appearing and arguing in recent times on two occasions, 2014 and 2019, the matter against Maratha reservation, my views may have sometimes some slant, but my idea is to give you law as neutrally as possible and what is the balanced and the right way to do things. Our constitution, when we talk of fundamental principles, one of them is equality and equal protection of laws, Article 14. So when you're talking of equality, equal protection of laws, then one would have normally assumed that there cannot be any reservation, there cannot be any quota, all are equal. But it is not so, because Article 15 deals with education and Article 16 deals with services or jobs, typically the jobs which are created by the governments, the local government, the state government, the central government. Both these articles, which are an extension of Article 14 in relation to education, which state must give to everybody or provide to everybody, and also jobs, because providing employment also is state's responsibility, do contain in each article subclause 4, subarticle 4, which expressly provides that 15.1 or 15 and 16 per se will not come in the way of government creating a special provision for certain people. 15 talks about socially and educationally backward, which is when it comes to reservation for education. 16.4 talks about who are socially backward. Now, there the word used is not educationally. I'll dwell upon why the difference and how the courts have interpreted it. That is what broadly you would all have heard of, read about in terms of judgments, etc. But the reservation of the quota doesn't stop there. If I tell you, you will say, yes, we all know about it. In terms of members of parliament, you have reservation, you have quota. In terms of members of legislative assemblies, you have reservation, you have quota. In terms of elections to municipalities, you have the same thing. In terms of panchayats, in terms of sarpanch, the prime of the panchayat, you have reservation in the quota. So it pervades in all spheres of life. And I'm just now not going to touch, but as we all know, one of the important aspects also is reservation for women. At one time, it was proposed that at least 50% members of the parliament should be lady members. It has been backed by each political party, but nobody has had the courage to table it and take it through as of now. Now, what are these so-called reservations or quotas for? Well, the beginning, historically, these reservations or quotas have been there in some states. I'm talking of the princely states, even prior to independence of India. In some states where a certain section of people were a little backward for whatever reason, in an attempt to prop them up, to improve their fate, to try to bring them at par with the other citizens of that state, some reservation, some quota system was adopted. Lot of books, when you read in relation to education or social development in different states, give some reflection on that. Typically, in and around Maharashtra also, some states, princely states, had something of that kind. This topic was a subject matter of great discussion in the Constituent Assembly when the Constitution of India was being framed and the members were discussing. And the question first was, should there be a reservation? Should there be a quota? And that is why came 15.4 and 16.4. Constitution said we do provide, or we do say that state can, based on social and educational backwardness or social backwardness in either case, make an exception. So a way was created in the Constitution itself. At that stage, this was termed as affirmative action. State can have an affirmative action so as to bring up the socially or educationally or otherwise backward people at par with other citizens. There was a discussion that if you say all must be treated equally, and if you provide for this exception, then what is the limit? Where do you draw a line? When you say a state can make an exception, to what extent can it make an exception? Interestingly, a lot of people said you must put this limit, that limit. What is oft quoted in most judgments is Dr. Ambedkar's statement. He said, I don't think it will ever exceed 50%. That by and large would be the highest, if at all in some cases. Because if you go beyond it, then it has eaten up the basic principle. Then where is the basic principle of equality? So all this is found in discussion. The Constitution is silent on this aspect. So the major controversies in judgments which you see in last few years is, can you exceed 50%? Because in one of the judgments, which of course is not the law now, a 7-judge judgment for that matter, the view expressed was that if in a given state 80% people are backward, then why can't you have 80% reservation? But that's not how the framers of the Constitution thought about it. And that's not how the law stands, fortunately for us now. Let's put the reservation into 3 or 4 categories. First is scheduled caste. Second is scheduled tribe. The third is the backward classes. And within that now, the nomenclature has changed. Earlier it used to be called other backward classes, OBC. Now we are talking about SCBC, socially and educationally backward. And then permutation and combination of these words different states are trying to use. I don't need to explain further. Scheduled caste, we all know, for maybe generations, maybe for centuries, they suffered a fate and they needed to be brought up. And therefore, they were decidedly, undoubtedly backward, and some support was needed for them. And therefore, there is a separate reservation in center and state for them. Scheduled tribes now. Again, the name is clear. If this is for that pocket of people in each state, which remained as tribals despite the rest of the country or rest of the world having moved in last 1,000 to 2,000 years much forward, from wheel to guns to aircrafts, but some people still remained tribes and they lived as tribals. They had no land to own because They lived in jungles and they thought that was their land. They owned it. They had no land to own. They had no money of their own. They had nothing which in today's world is considered worth the value. Of course, they were living in a very rich heritage otherwise, which was passed on from generation to generation. So they needed a support definitely. So there is not much controversy in terms of law when it comes to SC and ST. But the controversy is about classification of other people as backward. Call it OBC, call it SEBC, etc., etc. Some of the articles apart from 14, 15, and 16, which may be relevant, would be 29, 335, 243, some subsections or sub-articles of that which deal with municipalities, panchayats, etc., etc. I normally prefer to give a talk where I am talking extempore without reference to any judgments. But this time I propose to do exactly to the contrary, because the Constitution only reads as much as I have just told you. The rest is all a matter of interpretation as things developed in our country since independence. And these judgments, as a law student, you will find, if you have not read them already, make a very interesting reading. There are about a dozen 5-judge constitution bench judgments, 1 or 2 7-judge judgments, 1 a 9-judge judgment, and at one time it was proposed something should be referred to 11 judges. So you can imagine the importance. Now, why this importance? It's for the simple reason that this law, this system, this quota, this reservation, one way or the other, is going to determine the fate of large number of citizens or prospective future professionals, businessmen, industrialists, educationalists, etc., etc. Because depending upon what opportunity you get for education and job will be your contribution and will be your standing in the society. Resources are limited. Population is large. So everybody is not getting admission to a college or to a course of his choice. Everybody is not getting a job or an appointment of his choice. That is the importance of this quota system. So if you create a quota or a reservation and give a job or a admission to one person, the other is straight away denied. That's the importance. That is why you will find the deliberations are in detail. The largest, the 9-judge judgment in Indira Shane's case, which came post the Mandal Commission report and the reservation introduced by the then Prime Minister VP Singh, that runs into almost 900 pages. Mind you, there are about 5 different opinions, and each time I have read it and each time I have argued something in court, it's difficult to say with certainty, apart from few other things, what exactly is the ratio flowing consistently in all 5 judgments. It's rather difficult. Given that background, I'll quickly run you through some of the important judgments, the landmark ones, not all, and try to give you a flavor on what the law on the subject is as of now, and try and keep my comments, because as I said, because of controversy, to as minimum as possible. The first important one is known as M.R. Balajis Case. This goes way back in 1963. This was also a 5-judge judgment. In this case also, one of the issues was because in the state of Mysore, for reasons A, B, and C, the reservations are going at 73 to 80%. And the challenge was, how far can you go? And if you don't draw a line, then can you go to 99% or can you go to 100%? And if you go to 100% under 15.4 or 16.4, then what happens to 15 or 16 per se? Where do they go? This constitution bench refers to Constituent Assembly debates, refers to Dr. Ambedkar's statement as well. And this says that while the constitution doesn't insert that limit of 50%, it is only reasonable that becomes the highest limit. That becomes the limiting factor. In some rare exception for some reason maybe, but this must be taken as the rule of law that 50% is the limit. That is what the constitution framers thought, and that's the right way to balance it. This judgment talks of a few other things, but I'm skipping it. One or two judgments here and there, and we jump to 1976, which is N. Thomas. This was another 5-judge judgment. Two of the judges here expressing their opinions individually, which were not contradicted by the other three, but which are not also supported by the other three, said that the earlier judgments, when they talk about this 50%, that seems to be a observation in passing or a fond hope. But that's not saying that in law you can't have more than 50%. And that's where one of the judges said, if a state has 80% backward, why can't you have 80% reservation? Literally talking about proportional representation. That's very dangerous, let me tell you. Because if you were to say that, then each state would say, in my state, I have X% Christian, X% Muslim, X% Hindu, X% Jain, X% Sikh, and so much each will get. The society will get divided on numbers if that ratio was taken. But that was the view expressed by one of the judges in that judgment. Therefore, you had on one hand M.R. Balaji saying 50% is the rule. You had this N.M. Thomas where two of the judges expressed some disagreement, a possible difference of opinion, but not clearly saying what should be the law. Comes another judgment which says there seems to be divergence of opinion and this must be resolved once and for all. But it remained there till it came to the Mondal Commission, 1992, Indira Shane judgment. Indira Shane, as I said, is a very, very long judgment, almost 900 pages. They framed a large number of questions. They answered them all, but because there are 5 judgments, and it's not that on any specific topic, this one agrees with that, etc., etc. So it's a slightly difficult proposition to say how each topic comes, especially in this discussion here. When you're arguing in court, then of course you formulate on this proposition, 3 judges have said it, 2 have said it, 7 are in favor, 2 are against, like that you do it. But on this all important point, whether 50% is the upper limit, is the ceiling, the majority said, of course not all, mind you, majority said yes, 50% is the ceiling. They affirm Balaji, they reiterate Dr. Ambedkar's statement, and they say the very purpose of affirmative action is to bring others at par with those who are not backward. Idea is not to turn the table upside down, that those who are so-called backwards become the masters and the so-called not backward become downtrodden. That is not affirmative action, that's turning the table on its head. So that's not permitted. One would have thought that with such a strong 9-judge judgment and such a clear thinking, things would have settled and everybody would have followed the law. But that's not the case. There are quite a few exceptions being sought to be made by the state governments. 1 or 2 are, though under challenge, still in working. In the sense, the reservation in excess of 50% is prevailing, including in Tamil Nadu for a long time now, although the challenge is pending in Supreme Court, and including the recent Maharashtra amendment, which I'll in the end talk a little bit. The 9-judge bench threw up few other very important things. Firstly, it drew that distinction between 15.4 and 16.4. In 15.4, they said you will give reservation on the basis of social and educational backwardness, because 15 is about education. In contrast, it's not the same in 16.4. In 16, it is based on social backwardness. They said, but yes, in determining social backwardness, educational or economic backwardness may be some of the factors. They talked of something like a markless system. They talked about how you must have quantifiable data to determine who is backward, who is not. How it must be comparable to state average. To give you an idea, if you say that amongst Parsis, I'm saying because there's a non-controversial name in terms of community or caste. Amongst Parsis in Mumbai, 10,000 people are very poor. Their income is below 1 lakh per year. Therefore, Parsis are backward. Out of 10,000 students, 2,000 cannot pay their fees. So they are very backward. Well, that may be a criteria. That may be a way of putting it, and that may appeal to somebody. But the point is, in the state at large, whether other communities are backward 10%, 20%, 25%, how many are getting education, how many are not getting, how many have houses, how many do not, what is their earning capacity, etc., etc., etc. So you must, because in a country like ours, and just now in COVID times, you've seen how many shramik you are talking about, migrant labor. So these migrant labor come from every community. So if you say this community has 50 lakh migrant labor, this community has 30 lakh migrant labor, that may be very appealing and that may be right. But if that was the ground, then everybody will be backward. All castes will be backward. All segments of the society will be backward. And nothing is left. So they said, no, you must have quantifiable data. You must have a detailed survey. You must know what is your state average. And on certain parameters, if a community were to be treated as backward, they must be 10 or 20% below the state average. Not just on one parameter, but certain parameters. And for that, they talked of something like an objective marking system. This is something which was talked about for the first time in Indira Shane. Indira Shane, therefore, also talked of something very important, which is important in the context of maintaining the balance that I'm talking about. They said that if the states, by states I mean any government, were to go about creating reservation and quota in an indiscriminate manner, that is not in the interest of society. That is not what Constitution warrants. Article 13 clearly says that if a law is in breach of the fundamental principles, it can be challenged in court of law. We all know, we filed writs on that. But Indira Shane went 2 or 3 steps further. They said first that you can challenge a reservation or a quota if it is perverse, which means if you have no quantifiable data, if you have not done the survey, or if survey results show something else, but you want to do a reservation to the contrary. They also talked about if your percentages are unreasonable. Supposing a community is backward and that community or that segment of the society has 10%, is 10% of the state's population. Can you say I'll give 10% or 12% or 15% reservation? You can't. That will be unreasonable. So they said if the percentage is unreasonable, if there's no quantifiable data, or if the decision is perverse, so what? It's a decision of legislature. Because normally people say there is presumption in favor of legality of the law enacted by the parliament. But here they say no, the touchstone is the constitutional balance that we are talking about. If it finds foul of any of these 3 principles, then courts will entertain the challenge and will correct the mistakes committed by the legislature, by the parliament. Mind you, in the very first Balaji judgment, Supreme Court, speaking through unanimous voice, went this far and said that if you go beyond 50%, if you go beyond constitutional limits, then it's a fraud on constitution. I thought it was a very strong phrase. When I was arguing one of the matters, and I used the phrase in court, the judge raised the eyebrow. I said, this is not my phrase. This is what Supreme Court says, and says in emphatic terms. I'm only trying to highlight it. And he had a smile on his face. So this is how the judges have looked and frowned upon if you try to create an imbalance out of what was really an exercise in creating a balance. the controversy which continues to persist and on which I'll talk about the future judgments is that because Indira Shane said, while 50% is the rule and that must be sacrosanct, in rare cases, in some remote areas, in some specific situation, if you need to make an exception, you can possibly make it. One or two judgments later on explained it to say, supposing in one district in Maharashtra where there are a lot of tribals and 80% population is tribal. So they can say in this district in education, reservation will exceed 50% because 80% people are tribals living in this district. It's an exceptional situation. It can't be something which is prevalent across the state. It has to be in a remote area for a specific purpose, etc. Which got explained with these illustrations in one or two judgments later on. But as we all know, political class is different. And no party is an exception. All fall in that category because all work on ballot system. So they all cite this exception and try to bring in an elephant through a door from which possibly a mouse could have come. That's the whole controversy about. The second thing, which was also controversial in earlier judgments, was, can there be classes of backwardness within the backwards? That means backward or more backward or most backward. Different views were expressed earlier. Indira Shane said, yes, you can have classification, you can have classes. But going back again, the classification has to be intelligible. It has to be based on quantifiable data. It has to be based on a survey which is credible and which gives you the reason to classify them in this fashion. And it goes a step further and says that if you do that classification, then you must have separate reservations, separate quotas for the backward and the most backward. You can't put them in the same category, otherwise the classification has no meaning. But it left it at that. It also clarified at that point of time that even in terms of promotions in jobs, which is under 16 and 16.4, you can't exceed 50%. That rule applies even in promotions. Comes the next step. Parliament amends the constitution. It is spread over 4 or 5 amendments, 77th amendment going till the 85th amendment, 77th, 81st, 83rd, 85th. And they said that in relation to SC/ST, to be specific, if certain posts could not be filled up in the previous year or years, therefore promotions could not be given because candidates were not there, then that quota of the previous year can be used in this year, and to that extent you can exceed 50%. That got challenged in the court again, saying that this is against Indira Shane. That judgment is famously known as Nagaraj. This is again a constitution bench judgment. Nagaraj goes into great detail of Indira Shane. It confirms, reaffirms, yes, 50% is the rule. It yet says 16.4a and 16.4b, which introduced this amendment of exceeding 50% in relation to promotions for SC/ST, said will be held constitutional and is constitutional for the simple reason they said that you are not exceeding 50% per se, but because these people fall in a special backward class, and if their seats could not be consumed because nobody was available, and if you need to, through the affirmative action, bring them at par, there is no harm in maintaining this. But they put 2 or 3 cautions, which again are being blurred by government after government. First caution was that this is subject to the aspect of maintaining efficiency in administration, which means supposing in terms of doctors, in terms of scientists, you need us people of certain caliber at certain levels, typically more at the senior level. And I am not saying it, subsequent judgments give this example. then you may say that, so what, it was not filled up, but at the top, I can't bring in 4 people out of turn and fill up the entire top block, and rest of them are become now subordinate to the persons who were to whom they were subordinate earlier. This is an example given in one of the subsequent judgments. So administration and efficiency became an added factor when it came to the reservation under 16.4 in terms of jobs. That was another gift, that was another introduction from Indira Shah. M. Nagaraj, as I said, confirmed Indira Shah. M. Nagaraj said 50% is the rule. M. Nagaraj went a step further and says that the very fact that the constitutional amendment now says an exception can be made only for promotions, that means even Constitution now recognizes 50% is the rule. Although Constitution originally did not put this 50%, but now Constitution recognizes, following Indira Shah, that 50% is the rule, and the only exception is this exception. But the controversy still runs large in matter after matter. Then came Ashok Thapar, wherein this concept of creamy layer came. Because when you're talking of affirmative action, when you're talking about bringing up the people who were at a certain or a great disadvantage because of social, backward, or community reasons or historical reasons, for example, SC/STs, and they needed that support, then if my father is a qualified doctor earning a good salary in the hospital or having a good practice, if my father is a judge of the High Court, my father is an IAS officer at the highest level getting the best pay that the government pays, there's no reason why I should be getting now any advantage of any reservation or any quota, because I am probably as qualified, as advantageous as anybody else in the society. And if I were to get it, then those who deserve this quota, benefit of this quota, will never get it. So the creamy layer concept came in. This was being opposed strongly by political class. But the creamy layer concept comes in, which now all judgments accept, that while you do create a reservation, but you have an exception for creamy layer. My only objection, and that's my personal objection, nothing to do with law, is that things or the reins are always in the hands of political class. Where to draw a line and say where does creamy layer begin and where it stops, or where is drawing a line is in their hands. So supposing they were to say 1 lakh a month and above is creamy layer, then 12 lakhs. Well, for some 12 lakhs means nothing, but I think for most, especially in comparison to the lower and the upper, it makes a huge difference. Recently, you would have seen in newspaper, there's a controversy. What should be included? What income should be included in consideration for creamy layer? Farming income should be included or not, or this income should be included or not, or salary should be included or not, etc., etc. So those are all possibly ways to dilute the effect of this creamy layer thing. But for us as lawyers, the law remains that creamy layer is an exception. Ashok Thakur also gave one more thing, which is not being adhered to at all, because that Ashok Thakur only said that as a principle you can do it. Ashok Thakur said that while you may give reservation and it is desired and it is need of the hour, but that does not mean that in the name of reservation, anybody and everybody gets it. Which means, for example, in the general quota, people all above 90% are fighting and some at 92 or 93 do not get it. And in the name of reservation, you will say people in the other category, even if you have say 40 or 42 or 43%, I'll give you, which is happening in fact. Ashok Thakur said that no, you can draw a limit. You can say, I'll take people, for example, in the field of medicine, but provided you have, it didn't say 60%, that's my addition, provided you have certain minimum marks, say 60%. So you know that the student is of average or average plus intelligence. But if you bring in somebody with 36, 38, 40, 42, 43, if those are the pass marks, the statement may be a bit controversial, but it creates a lot of difficulty. First, the student finds himself at a difficult end in the college. In many places, they take almost 1.5 to double the time to clear the course. And 3, unless they improve during the course of education, when they come in job and other things, the inefficiency becomes a very difficult task. So constitutionally, the Supreme Court was very clear. Reservation does not mean that you pass and you get it. There can be still certain minimum qualifying marks, certain minimum entrance standards, and those must be prescribed. But by and large, that is not being done by any of the governments. Then I'll talk about these last 3 or 4 judgments. I don't want to stretch beyond our time limit. You must have heard about reservations for Jats in Haryana, in Rajasthan, in Delhi, in UP, a major topic. Some reservation for Gujars in Rajasthan. Some reservations for a particular caste in Gujarat. Some reservation for Marathas in Maharashtra. In 2014, just before the elections, Congress government approved it. In 2019, just before the elections, BJP government approved it, etc., etc. Now, incidentally, all these reservations take it well beyond 50%, because everybody is sitting on the brink of 50%, 48, 49, 50. Maharashtra, incidentally, reservation stood at 52% for last about 15, 20 years. So all these were additions. Now, going back to Mandal, the thought was this: if you have affirmative action, if you do support people in education and jobs, then in 10, 20 years time, 25 years time, their fate must improve. Their average caliber must improve. Their average marks given for backwardness must improve, so that some classes will get out of the category of backward class, and some, those who have now become backward in comparative terms, will come in, so that the affirmative action is a dynamic process and those who need it get it. That was the thought in Indira Shahne. Not a single class or community has been excluded before or after Indira Shahne. It has not happened. Possibly nobody has the courage to do it. In Jat reservation case, when the Supreme Court was dealing with it, it came with this term that just because a particular class or community is politically organized does not mean that you give it that reservation. And they considered Jats coming from Haryana, Rajasthan, UP, etc. in that category. They said because you have clout in politics, you have clout in assembly or parliament, you have clout in the bureaucracy. So you somehow create an environment to say we are backward, therefore we must be given reservation. That's not enough. They also emphasized that look at your competitive figures. How are, compared to other communities or castes or the state average, you are worse off, you are not. So that reservation was struck down. It made a very telling comment. It said that even after 25 years, if you say that nobody has become forward and more people are becoming backward, so we need to create more and more reservation, that means your process of reservation has completely failed. It has not given you any results. Very telling comment. It was a tongue-in-cheek way of saying it, but to say that this is not how you look at backwardness. A very strong comment on that. But mind you, that doesn't deter the state governments from doing what they want to do. One of the judgments, even before the Jat reservation judgment, was Rakesh Kumar, 2010, where they were dealing with reservations in panchayat. They reaffirmed the 50% rule. They said, yes, that is the rule. 9 judges have said it and we abide by it, and that is the rule. That was their interpretation of 9 judges. And they said, whatever is the system of reservation under 15.4 and 16.4 can be equally applied in relation to elections for Panchayati Raj. Came next in the same year, K. Krishnamurthy. Similar findings, similar position, And they said same principles can be applied even in relation to elections for municipal councils or for local bodies. Because these are all, as you know, dealt with in separate chapters, separate parts of the constitution. But in each place, whether it's parliament, whether it's panchayat, whether it's municipality, whether it's assembly, the member is representing the people from that city, from that constituency. So every community, even the so-called backward or SCs or STs, must also have that chance, because then only their point of view will be looked into and their problems, their difficulties can be voiced, and possibly they get a fair share of hearing and dealing. So therefore it became now all pervasive at all places. Yes, this reservation. K. Krishnamurti made two things very clear. They said that when you read Nagaraj, and when it says you need quantifiable data if you want to make reservation, because Nagaraj said that even under 16(4)(a), 4(b), if you say you need promotions more than 50%, you must have data, etc. K. Krishnamurti made it very clear that this will apply when you are dealing with backward classes. They said SC and ST, you don't need quantifiable data because they are backward. You don't need any proof to show that they are backward. SCs and STs, as I said in the beginning, the reason why they are backward, and that's writ large, so you don't need it. So they said for them, you don't need quantifiable data or proof. In terms of providing reservation, of course, if it is unreasonable, if it is beyond a number, if it is perverse, then you look into. But per se, to say that to provide reservation for SC and ST, you don't need quantifiable data to prove that they are backward, because they are backward. That is given. Judicial notice is taken of that. That was a departure that they made from M. Nagaraj, and they said otherwise M. Nagaraj is good law. M. Nagaraj follows Indra Shane, we follow it, 50% is the rule. And they highlighted this principle that when it comes to promotions, which M. Nagaraj said you can sometimes make it beyond 50% for taking it the past year's quotas. They said, but it need not necessarily be applied universally. You can say it will apply up to a certain level and not beyond certain level. You can say it will not apply at the top level. You can say it will apply at the top or top -1 level only to a certain extent, not beyond. Because all this was in the interest of efficient administration of the state affairs. So you can't, just because you want to support a particular set of backward people, you can't do this at the cost of compromising the efficiency in administration of the state. They had highlighted this very strongly. Although, as I said, we don't find any state having courage to draw this line. Ram Singh was this Jat reservation case, which I just explained to you. One was, they said, just because you are politically organized class, you don't get reservation. Just because you have agitation, you have rasta roko, you have burning of buses, you create hartal, you do dharnas, and you threaten the state directly, indirectly, peacefully, otherwise. That's no reason, because then who will be left out? And second thing they said, because in Jat case, there they said, oh, look at this community in this state, their number is slightly above this or slightly below this. They are backward, so why should we not be? They said, no, your backwardness is not to be judged by reference to a particular community in one particular segment. Your backwardness has to be judged on overall criteria, on overall backwardness, under 15 differently, under 16 differently. And the criteria are as given in Bundle Commission or whatever new criteria you develop. So you can't say somebody else sitting here on these one or two aspects, he is better than me, he is still under reservation, so I need to be under reservation. They said, no, that's not the objective criteria, that's not the way to look at it. Recently, Justice Nageshwar Rao had occasion to deliver a judgment. I have not noted the name. It's a recent judgment about 2 or 3 months back, which reiterates the principle and which strikes down the reservation, which was unconstitutional. That's broadly the position. As I said, I had appeared in Maratha case, so I'll not go into the controversy matter. It's still pending in Supreme Court. But if you see a 2014 judgment of Chief Justice Mohit Shah, it Can you hear me now?
Yes, sir.
So in 2019, a judgment delivered by Justice Morris, which has approved or which has held that the reservation in excess of 50%, that is, the reservation is valid. It offers an interesting reading. In the backdrop that I've given you, you will know what the controversies are and how courts have looked at the law in this regard. One of my juniors, I must say that in these matters, you need a lot of assistance. A lot of juniors work in different matters. One of the juniors, Pallavi, who was helping me recently, she has made a small 3-page note. I forgot to share it, but I'll send it on email and you will all have access to it. And you will get some brief flow of judgments as to how the law is developed. Thank you all for giving me this patient listening.
Sir, there are few questions. Would you like to answer them?
Sure, no problem.
Among the SC and ST, do you think that there is upliftment of the better of section and pushing down the downtrodden?
Repeat it, please.
Among the SC and ST, do you think that there is upliftment of the better of section and pushing down the downtrodden?
You are asking for my opinion. I would tend to agree. But as I've been saying, it's a very controversial topic. We have reached a stage, I'm saying it in very, very muted words, not openly. We have reached a stage where within both these categories, there are 4 or 5 different classes, and each class is into that category of Brahmin, Vaishya, Shudra, and whatever. It's that bad.
Next question. In every cases of reservation, the term quantifiable data is submitted by authority into suit them in favor of reservation. But who and how will actually verify the authenticity of quantifiable data?
You are right. When I was arguing a few years back a matter, and I said this data is wrong, and I was able to show this data is wrong. At that time, the then Advocate General got up and said, but where is your data which you say is right? You can't just attack me and say it is wrong. Fortunately, the judge was open, the bench was open, and I was able to say, if the state with its might cannot get you the right quota after spending so many months or so many years, how do you expect a public interest litigant to get it? So, but the question still remains open. If the state completely fudged the data, then what happens? Well, at this level, where you have to have data from the entire state, quantifiable data, you can fudge one document, you can fudge one table, you can fudge one survey. When you do it wholesale, there are telltale signs, and you are able to show it to court, and court knows that there is something wrong, terribly wrong here.
Yes, sir. So with this, we come to an end. Thank you, sir, for enlightening us on today's topic. It was indeed a very informative session for all of us. And I'm sure the same will surely help us in uplifting our profession to new heights. We are looking forward to have many more sessions by you in the near future. Thank you, sir.
Thank you. Thank you very much. Thank you very much. Stay safe. Thank you.